A void contract, also known as a void agreement, is not actually a contract. A void contract cannot be enforced by law. Void contracts are different from voidable contracts, which are contracts that may be but not necessarily will be nullified. An agreement to carry out an illegal act is an example of a void contract or void agreement. For example, a contract between drug dealers and buyers is a void contract simply because the terms of the contract are illegal. In such a case, neither party can go to court to enforce the contract, although some drug users mistakenly believe the opposite and therefore take their disputes to court. The next will be the lack of essential elements. Inexistent and void contracts cannot be ratified, neither can the right to set up the defense of illegality be waived. They are the following. First, those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. Second, those which are absolutely simulated or fictitious. Third, those whose cause or object did not exist at the time of the transaction. Fourth, those whose object is outside the commerce of men. The fifth one are those who contemplate an impossible service. Number six, those where the intentions of the parties relative to the principal object of the contract cannot be ascertained, and those expressly prohibited or declared void by law. Prohibited contracts. This relates to the following persons who cannot acquire by purchase, even at a public or judicial auction, either in person, through the mediation of another, under Article 1491, paragraphs 4 and 5 of the new Civil Code, which states, public officers and employees, the property of the state or of any subdivision thereof, or of any government-owned or controlled corporation or institution, the administration of which has been entrusted to them. This provision shall apply to judges and government experts who, in any manner whatsoever, take part in the same. Justices, judges, prosecuting attorneys, clerks of superior and inferior courts, and other officers and employees connected with the administration of justice, the property and rights in litigation of or lived upon an execution before the court within whose jurisdiction or territory includes the act of acquiring by assignment, and shall apply to lawyers with respect to the property and rights which may be the object of any litigation in which they may take part by virtue of their profession. So, what is to be filed in court? In order to follow the rules of law regarding void or inexistent contract, the action to be filed in court is an action for the declaration of nullity. According to the Article 1410 of the new Civil Code, the action or defense for the declaration of the inexistence of a contract does not prescribe. However, it does not apply to last will and testaments. So, how illegal contracts with criminal offense should be treated? According to Article 1411 of the new Civil Code, it states that when the nullity proceeds from the illegality of the cause or object of the contract, and the actions constitute a criminal offense, both parties being in pari delicto, they shall have no action against each other, and both shall be prosecuted. Moreover, the provisions of the Penal Code relative to the disposal of effects or instruments of a crime shall be applicable to the things or the price of the contract. This rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given and shall not be bound to comply with his promise. no consideration, restitution after void contracts. Those who transfer value under void contracts have no remedy in contract and little to expect from the law of property since nullity does not in general prevent property passing. However, it has been recently held in litigation following void interest swaps that the value transferred under a void contract, because it passes for no consideration, becomes an unjust enrichment of the recipient of transferor's expense, so that restitution must follow even where the void contract has been fully executed on both sides. Restitution for no consideration is an alien to the law of unjust enrichment in the common law in particular. Number 1. Parties to a fully executed contract, though it is void, have no substantial reason for restitution. Next, failure of consideration, properly understood, can explain all cases of restitution where the defendant has not completed his part. Next, cases advance as warranting a new ground of restitution called no consideration and distinct from the failure of consideration turn out on closer inspection not to go beyond the failure of consideration. Next, the new doctrine creates an unacceptable discontinuity with the past, unsettling the foundations on which leading cases have been argued and decided, departing from the previous treatment of void contracts and contracting the leading treatise on restitution. These arguments notwithstanding, it will be true that in a jurisdiction that allows restitution for mistakes of law, the results illegitimately attained through no consideration will be largely attainable through mistake. Nevertheless, the further progress of no consideration should be resisted because it constitutes a standing invitation to borrow the language of civilian systems, and civilian terminology can only do harm if it is imported without civilian substance. That would be all for today's video. Thank you so much for listening, and I hope you've learned a lot from my discussion.